Hello, my name is Meg Kinnear, and I am the Secretary General of ICSID. I'm delighted to be able to join you by video today, although I do wish I was there in person at the Seoul ADR Festival. It's certainly one of the events that I've enjoyed in the past, and I hope in the future we'll be with you in person again. Last year, I talked a little bit about the ICSID amendment process, and I'm here this year to report back that we have concluded the process and are implementing the rules. And I'd like to give you some of the highlights of what ultimately was adopted by our member states. The amendment process for ICSID began in 2016, and we went through what ultimately became the most comprehensive process of amending our rules, but also the most transparent process to amend our rules. We went through essentially 6 iterations of draft text, and while that did take about 5.5 years, I'm certain that the time was well worth it to get a well-drafted set of rules that garnered consensus. At the end of the day, our members voted on March 21st of 2022, and these were resoundingly approved with more than 85% of the vote in favor. The amended rules came into force on July 1st of 2022. The text of the new ICSID rules has been posted on the ICSID website, and hard copies will be available in November of this year. You will find that each set of rules is in a separate booklet, so you will have all of the tools you need for that kind of arbitration, conciliation, mediation, or fact-finding in the relevant rule booklet. As a result, the blue booklet is for convention cases, so it contains the ICSID convention, the Executive Director's report on the convention, the administrative and financial regulations, the institution rules, the conciliation rules, and the arbitration rules. The yellow booklet gives you all of the materials you need on additional facility. So they have the additional facility rules, the additional facility administrative and financial regulations, the additional facility arbitration rules, and the additional facility conciliation rules. Thirdly, the Green Book contains the new mediation rules with their own administrative and financial rules. And finally, the Red Book contains the new fact-finding rules with their own administrative and financial rules for fact-finding. In addition, we have updated our website so it contains an extensive commentary on the new rules and an explanation on each of these rule sets. This website will be dynamic and continue to grow over time, including with any case law issued interpreting the new rules. The overriding goal of our amendments was to modernize the rules and to ensure that they stayed fit for purpose while maintaining the many strengths of the current system. The amendment rules have also responded to various requests for reform of the investor-state process, and they have formally introduced many practical improvements that we had learned over the years in case administration. In particular, these new rules seek to achieve greater efficiency while they maintain procedural balance between investors and states. They have strengthened the provisions on conflict of interest and avoidance of conflict. They have increased transparency of the process, in particular public access to decisional documents, public access to hearings, and the ability of non-disputing parties or non-disputing treaty parties to participate in the process. Finally, they offer a broader range of dispute settlement options for investment disputes. As a result, there are 4 sets of rules, each with a slightly different approach to dispute settlement that the parties can tailor to what they need to come to the best resolution possible. The first particular rule I wanted to draw your attention to is the third-party funding rule. This is a brand new rule that applies in both the arbitration and conciliation rules. Its purpose is to avoid inadvertent conflicts of interest between arbitrators or conciliators on the one hand and third-party funders on the other hand. The rule requires both disputing parties to file a written notice as soon as the request for arbitration is registered, or immediately upon securing third-party funding if that happens later in the proceeding. It is a very simple notice and there is no special format for the notice. However, it must contain two basic things. First of all, it has to state the name and address of the funder and the names of those who own and control the funder if it is a juridical person. This notice is sent by the parties to the ICSID Secretariat, which will circulate it to the disputing parties and the arbitrators in the case. And with this information, you will have what is needed to determine if there is a potential conflict between arbitrators and third-party funders in the case. I wanted to note that while it is possible to ask for further disclosure arising out of the funding agreement, this is not a discovery provision, and that type of information would only be given if it was absolutely necessary to determine whether there is a conflict of interest in the case. The next set of rules go to the overall objective of reducing time and cost, and this, of course, was one of our key goals. As we looked at the ways you can reduce time and cost, we realized that, not surprisingly, there is no one cause of delay, and so it was necessary to have several approaches to this objective, and in some cases, have these objectives work cumulatively. So, for example, the rules start with a general obligation on both parties and arbitrators to act in a timely manner. All documents must be filed electronically, and parties have the option, as do arbitrators, to hold any session or hearing by video, by telephone, or in person. Alternately, they have the option to hold sessions and hearings in a hybrid format, if that's what they wish. A number of other provisions support the goal of reducing the time of proceedings by encouraging proactivity by arbitrators. Probably the best example of this is Rule 31, which relates to case management conferences. Every case is required to have at least one case management conference, and it's hoped that these will occur regularly throughout the case when there is an opportunity to simplify the case or to simplify the procedure being used. Another good example of tools to increase the time effectiveness of the rules is Rule 46, and that gives a procedure to consolidate like cases into one single proceeding, or where it is impossible to consolidate, perhaps because of jurisdictional limitations, to coordinate specific aspects of parallel cases. In many cases under the new rules, the time limits that are applicable have been clarified, and in some instances, these have been reduced. Probably the most important set of time limits that have been clarified are those relating to decisional documents. As a result, a tribunal is expected to render an award on merits and jurisdiction within 240 days, or 8 months, after the last submission. Similarly, a tribunal is expected to render procedural decisions in most cases in 30 days after the last relevant submission. These time limits must be applied and met, and a tribunal has to use its best efforts in meeting these time limits. If a tribunal requires an extension, it has to advise the parties in writing of special circumstances justifying a delay and the length of the delay required. As well, parties can mutually agree on an extension, but if they are unable to reach consensus, a request for extension of time has to be based on a reasoned application that is made before the time period in question has expired. The new provision dealing specifically with security for cost has been added under Rule 53. You may recall that security for costs used to be dealt with as a provisional measure and with the tests applicable to provisional measures. The new provision provides a specific test that tribunals must apply. In particular, it states that tribunals have to consider all evidence related to the circumstances surrounding the request, including, first of all, a party's ability and their willingness to comply with an adverse decision on costs. Secondly, and to balance the equation here, the tribunal must consider the effect of ordering security for costs, and in particular, what impact it may have on a party's ability to pursue its legitimate claim. Thirdly, the tribunal has to consider the conduct of both parties before ordering security for costs. Notably, the mere fact that a party has third-party funding does not justify security for costs. Rather, tribunals have to apply the test in this rule, and the point of the test really is, what is the likelihood of not satisfying an award of costs if that is ultimately made by the tribunal? The next topic I'd like to address is transparency, and you will note that these new rules have continued the direction of the 2006 amendments in increasing transparency. This set of rules focused especially on transparency of decisional documents, in other words, awards, decisions, and orders. Awards will continue to be published with the consent of the parties in ICSID convention cases, as is currently required by the convention. However, the new rule adds that if neither party objects to publication, their consent to publication will be deemed to have been given. If there is an objection, ICSID will extract the legal reasoning as it has done in the past. In terms of orders and decisions, these will all be published with redactions agreed to by the parties, and the new rules contain a process for any dispute about redactions to be resolved. The amended rules also provide for publication of a party's own pleadings as long as they have redactions agreed to by the parties or decided by the tribunal, again so that they do not disclose any confidential or protected information. With respect to hearings, there is an assumption that hearings will be open unless either party objects to an open hearing. Another set of rules that addresses the time and cost considerations of the new amendments is the set of rules on expedited proceedings. There is a full chapter on expedited arbitration. Essentially, it provides that the parties may consent to using expedited arbitration in their ICSID convention or additional facility cases, either by consenting to the entire chapter being applied or, if they wish, to selected provisions that address expedition of proceedings. If followed as written, the expedited arbitration rules would reduce the time of a case by roughly 50%, so you can see that it may have a very significant impact. We recognize that not every investor-state case will be apt for expedited arbitration, but we do think it may be a very useful tool for states to promote foreign investment by small and medium enterprises, cases arising out of contract, and some treaty cases that might have facts that are not overly complex or that do not rely on disputed public international law concepts. Another set of changes are in the additional facility rules. These have been significantly updated. Parties should note in particular that the new additional facility rules will significantly broaden access to the additional facility. This is done in two main ways. First of all, additional facility cases can now involve parties that are both from a non-ICSID member state. So you may recall under the old additional facility, the cases were limited to situations where either the claimant or the respondent was linked to an ICSID member state or was a national of a member state. This is no longer the case, and you will be able to have additional facility arbitration or conciliation where one of the parties is affiliated with an ICSID member state or where neither party is affiliated with an ICSID member state. So this broadens the access to those rules. The second way in which the rules broaden access is that a regional economic integration organization, an REIO, can now be a claimant or a respondent in an additional facility case as long as the REIO has consent to ICSID additional facility in its treaties or contracts. REIOs, as you know, are regional economic integration organizations, and we often think of, for example, the European Union. And what we know is that REIOs increasingly are signing investment treaties in their own right. So having access to the additional facility for the REIO either to be claimant or respondent under these instruments of consent will be important to parties, making sure that their rights are vindicated under the treaty and through the ICSID additional facility rules. Another of the new rules has been the updated fact-finding rules. These again have been significantly updated, and they are now stand-alone rules. Under these rules, the parties can jointly request a fact-finding committee, which will determine a procedural protocol and ultimately make specific fact findings in a dispute. We know that this can be very useful in the pre-dispute phase to help try and prevent a dispute arising where one or two fact findings is what constitutes the difference between the parties. We also know that fact finding may be useful in the middle of a case where it becomes evident that a particular fact finding is the difference between the parties. So these are now available for parties. The last set of standalone rules that I'd like to bring to your attention are the new ICSID mediation rules. These are an entirely new set of rules. They are available between parties in a dispute relating to an investment, so fairly broadly available. And secondly, they are available even if the parties are not nationals of an ICSID member state or are not an ICSID member state under the ICSID Convention, again making them broadly available. A mediation under these rules can be commenced under an existing agreement, or they can be agreed to by the parties on an ad hoc basis. This reflects the fact that while increasingly we see treaties with a specific mediation clause, there are many treaties that don't have mediation clauses, but in which our rules will be available if the parties consent to having a mediation. Parties are able to commence a mediation at any time in the process, and indeed might even opt for mediation before a formal dispute has been filed, for example, in the consultation or cooling off period in a treaty. On the other hand, parties might want to have a mediation in parallel with an arbitration, or they might want to take a pause in their arbitration to have a mediation where matters have become more clear and they think that they can benefit from a mediation process. So they are very flexible in terms of when you might invoke them. I'd also note that the mediation rules have specifically been aligned with the formal requirements of the Singapore Convention, and this, of course, will enhance the enforceability of any resolution that's been reached through mediation. So we hope that this will help encourage more mediations and that this set of standalone rules will help us to emulate the kind of success of mediation that we've seen in commercial arbitration. I hope that this presentation has given you a flavor of the new rules and a sense of what are the biggest changes that we have made. In the meantime, if you have any comments or questions, please do consult our website, the rules themselves, or please send us an email and we would be happy to discuss these further. In the meantime, I wish you a wonderful conference and a very productive day.